How can a permanent resident or U.S. citizen file for their children? What if that child is an adult? And by that I mean over the age of 21. Does it make a difference if it's a permanent resident parent petitioning for the son or daughter, or if it's a U.S. citizen petitioning for the son or daughter? What if they're adults and they're married? Does it make a difference? These are some of the questions we're going to be answering in today's video. If you're new to my channel, I'm Puyan Darian, an attorney focused entirely on family-based immigration, and I make videos on a weekly basis on specific family-based immigration topics. After each video, I encourage people to write these questions in the comments below, asking what they may be wondering after watching the video or what their experiences were. And this video is specifically a response to some questions I received about what the process looks like when someone is filing for minor and adult children. The first thing I want to discuss in this video is when a U.S. citizen parent petitions for a child. And by child, again, I mean anyone under the age of 21. Even if they're 20 years old, it's all the same. So this is referred to as an immediate relative petition, which is differentiated from a preference category petition, which will be every other type of petition we discuss in this video. It's important because an immediate relative petition, so when a U.S. citizen parent petitions for a minor, gets around a lot of the immigration rules that might make you otherwise inadmissible. For example, that child can be out of status as long as they entered legally or with parole or with some sort of visa. They might be able to benefit and become a permanent resident from this petition even if they entered the U.S. 10 years ago. They can be entirely out of status and have no immigration status and still become a permanent resident through a U.S. citizen parent who's petitioning for them. They could apply for adjustment of status in the United States. This is very different from a parent who's petitioning for a 21-year-old or older son or daughter who's in the US out of status. In fact, that son or daughter likely won't be able to apply for permanent residence directly from this type of family petition. You have to be in a valid status if you're going to be in a preference category petition, and I'm going to explain exactly what all of that means. When a U.S. citizen or permanent resident parent is petitioning for an adult, someone over the age of 21, all of these petitions will be referred to as preference category petitions. A general rule for all preference category petitions is that the beneficiary, so the adult son or daughter, cannot be out of status. If they're in the US and they've overstayed their visa, they likely cannot benefit from this type of family petition through the standard adjustment of status green card process. They will need some other way to fix their immigration status. Now, what if they're in a valid visa status and they can maintain that status? Or they're outside of the US and they've never overstayed, they've never been in the US, or they came and then they left pursuant to a valid entry and departure. What do the processing times look like? And what does the general procedure look like? Well, we're going to be discussing all three of these categories a little bit separately. And these categories are U.S. citizen parent petitioning for an adult son or daughter, permanent resident parent petitioning for an adult son or daughter, and a U.S. citizen parent petitioning for a married adult son or daughter. Notice that I don't mention a permanent resident petitioning for a married son or daughter because there is no such category. If your son or daughter is an adult and they're married, you need to become a U.S. citizen to even file the petition for them. What I have in front of me is a printout of the visa bulletin for July of 2023. You can access the most recent version of this by just Googling Department of State Visa Bulletin. It'll bring you to a website where you could click and access the bulletin chart for the most recent month. These numbers update from month to month, and what this chart shows you is all of the different preference categories and what the processing times are. So specifically, the chart shows priority dates, and the priority date corresponds to the date that the family petition was filed. So there are two notable numbers here. The first category F1 is unmarried sons and daughters of US citizens. And currently, the government is processing applications with a priority date of December 2014. So that's like a 7-year delay just until the family petition can be acted upon, and then you can continue with the immigration process, which will likely take at least another year. Now, let's compare that to a permanent resident parent filing for an adult son or daughter versus a US citizen parent. That's actually, and interestingly, 1 year faster. They're currently processing applications from September 2015 versus US citizen parents, which is December 2014. So that's a little bit of a weird outcome, and this is largely because these numbers depend on how many people file petitions in that category on a yearly basis. So there are more people who are US citizens filing petitions for adult sons or daughters than permanent residents. Now, what happens if you are a US citizen parent, you're petitioning for your adult son or daughter, and while the process is pending, they end up getting married? Well, actually, the priority date for that category for most countries is December 2008. So you're adding 6 years just by your son or daughter getting married. And this is where the problems arise. You know, a lot of people will ask me like, hey, I'm a US citizen, my son or daughter is right here in the US, they overstayed their tourist visa, can I petition for them? Or even worse, another attorney petitioned for them, now that petition got approved, can you apply for their green card? And this is when I have to have the difficult discussion with them and explain, actually, the fact that that petition got approved only means that you are a US citizen or permanent resident, and this is in fact your son or daughter. That's all that that means. It's a prerequisite for applying for permanent residence. It doesn't mean your permanent residence application will get approved. And that if we apply for adjustment of status in the US, since your son or daughter is out of status, this application is going to get denied, and you're going to be wasting a bunch of money if you go through this entire process right now. Let's take an example to try to clarify what I've been trying to explain in this video. So if you're a US citizen parent and you have a child who entered on a student visa or a tourist visa when they were, 18 years old, and they fell out of status, they overstayed the tourist visa, or they stopped going to school and didn't renew their student visa, and now they're 20 years old. You can file an immediate relative petition for them and they can become a permanent resident even though they're out of status. And it'll be pretty fast as it takes to process the petition. There is no statutory waiting time or waiting period for any priority date to become current. What if you wait a year until they turn 21? Well, best case scenario, you've now probably added like 8 years to the process. By waiting 1 year, you've added 8 years. But actually, if they're out of status, they won't even be able to benefit from a family petition from a parent anymore. The only way they can get an immediate relative petition after the age of 21 is by marrying a US citizen. So they might have other immigration options available, but family immigration is going to be severely restricted at that point to marrying a US citizen. What are the key takeaways from this video? Well, first of all, don't wait. If you are able to file a family petition for your child or adult, do it as soon as possible. But you should really speak to an immigration lawyer first, because I can't tell you how many times people have come to my office saying, look, we filed this family petition by ourselves. We paid the $535 government filing fee and it got approved. We have a paper that says it got approved. And I have to give them the unfortunate news of explaining, yeah, but your adult son or daughter who's like 22 right now and was over the age of 21 when you filed the petition is in a preference category and they can't become a permanent resident through this approved family petition. I get that it's approved, but that doesn't mean they can become a permanent resident through the petition. All that the petition means is that you're a US citizen and this person is related to you. They're your son or daughter. That we submitted a birth certificate and your proof of citizenship and the petition got approved. You probably actually wasted your money if they're in the US and they're out of status. Now, if they're outside of the country and they have no history of immigration violations, that's a different story, and they might still be able to benefit from this down the road and enter the United States once their priority date becomes current. I've also seen situations where a US citizen parent says, I can do this myself, and they filed all the paperwork themselves for a 20-year-old. And then the 20-year-old turns 21 and the petition has some sort of problem and ends up getting denied. And now we have to refile it, and they're over the age of 21 and they lost the opportunity because they don't have a petition that predates their 21st birthday. If the kid turns 21 while an immediate relative petition is pending, they might actually benefit from something called the Child Status Protection Act, which freezes their age and creates some new age calculation. This is a topic for a whole new video, but my point is, don't play with fire. If your child is turning 21 within the next year or two, I strongly recommend at least consulting with an immigration lawyer before you decide what is best for you and your family. All right, guys, that brings us to the end of this video. If you have any experiences you want to share or specific questions about the topics I discussed in this video or other videos, post them in the comments below. I'll try my best to eventually answer your questions. And as always, be sure to like and subscribe. And if you need a consultation to discuss some sort of immigration issue, you can always book it directly through my website or call or text my office. And I'll see you guys next week for another video.